Good morning. Question of waiving the period of 6 months after filing petition for divorce under 13(2) uh, is one of the most critical field wherein somebody may get instant waivement and somebody may not get that. So here in the given case, AR 2021 Allahabad 164, Priyanka Chauhan was a principal judge, family court. The application filed under section 17 was dismissed because there was no reasons to allow this application. But the division bench of Allahabad High Court held that divorce by mutual consent statutory period of 6 months for second motion provision is directory in nature. Cooling off period can be waived under certain circumstances. This they are held. They are discussed about 17C of Indian Marriage Act, 18C for Indian Marriage Act, 13B2. Then they have given several guidelines. What all are the circumstances the period could be waived? So you also referring several Supreme Court judgment, you keep this judgment on your file and record so that it may help you. But you have to state specifically by following the judgment wherein they have given certain categories of circumstances upon which you can claim waiving of cooling period of 6 months. So you put some government answering this requirement to consider it. So then I will come to important provisions of as I have already held IPC. I already discussed with you about the importance of 34. If it is less than 5, then section 35 would apply. If it is more than 5, then question arises. What all are the provisions apply for punishment? First, before that, I would like to you to go through the judgment. Several judgments are there discussing about 149. But one Ashish Ranjan versus Union of India 2018 6 Supreme 55. They say section 148 324 read with 149. High Court modifying conviction under section 147 148 323 504 307 read with 149 to one under section 148 and 324 read with 149 with the default sentence and fine. Then they say Allah they are this. Then they say in another judgment, that judgment will be more powerful. Joseph versus State of Tamil Nadu 2018 1 Supreme 197. You must go through the entirety of judgment. For your convenience sake, I will read it. 149. Factor deciding whether assembly had a common object to cause murder of the deceased. Nature of weapon use, manner and sequence of attack made on the deceased, and the circumstances under which the occurrence took place. It is an inference to be deduced from the facts and the circumstances of each case. Instantly, accused 1 to 11 did not have common object of killing deceased. Secondly, accused 4 to 10 did not have knowledge the deceased would be killed. Therefore, they have set aside punishment under section 302 read with 149. There they have discussed about the difference between 143, 144, 8 and other cases. Then they have acquitted him. So you go through that. Then another judgment which deals with clear case. How to understand the provisions of Vinubhai Rachhodbhai Patel versus Rajivbhai Dhanush Dudabhai Patel, 2018-5 Supreme Court 453 2018. There they have deeply discussed about the differences between 141. They say declares an assembly of 5 or more persons, they are punishable for common object, that means riot. Then mere assembly itself is an offense. Then they have discussed about 146. If force or violence is used by unlawful assembly, rioting means agitation without permission, all this would come under 143, and 146 says if anything had happened, throwing up stone, assaulting or causing injury, then they say 146 would apply with 2 years punishment. Then 148 says declares that rioting armed with deadly weapons. If a knife and gun is carried to assemble, then question of 148 would come into picture. But 149 imposes vicarious liability. This is what the judgment of Supreme Court says. Vicarious liability is meant for civil proceedings only, but in criminal, if the legislative command is there for vicarious liability, you are bound to answer for that, and punishment would be there. That they say vicarious liability is applied very sparingly in criminal law, only when there is clear legislative command. Then they say the most important thing, they say 149 have two clear part. There were two clear part for 149. That you have to understand 140, how 149 is having two clear parts. 149 declaratory of the vicarious liability of members of unlawful for acts done in persecution of common that assembly or for such offences as the members of the unlawful knew likely to be committed in possession of that object. That is most important. They say that way 149 creates a specific or distinct offence. So there should be charges. To invoke 149, section 141 have to be established. Once two ingredients of 149 are found fulfilled, it would be neither be open to the court to see who actually did the offence or not. That is most important. The first part of the section 149 means that there exists common object and that offence has been committed in persecution of the common object. In order that the offence may fall within the first part, the offence must be connected immediately with the common object of which accused was member. The second part of the section means that even if the offence committed is not direct persecution of common object of the assembly, it may yet fall under section 149 if it can be shown that the offence was such as the member knew was likely to be committed. This is most important to be understood. So you have to go through 141, 143, 147, 148, 149 and 149 carefully with two distincts: when directly offence has been committed or when the person knows that the offence, possibility of committing offence is there. This is most important to understand so far unlawful assemblies are concerned, and definitely there will be a question of descriptive nature as well as objective. So what is the difference between 143 147, 148 and 149, part 1 and part 2. So kindly go through these judgments and you must get this judgment. Best wishes.